now like to turn the conference over to Mr. Shepard. Sir, you may begin.
Thank you very much. Good afternoon and welcome to session 3 of our post-employment massively open online course. I'm Patrick Shepard and I'm very pleased to be joined today by Cheryl Kane-Piasecki. Welcome, Cheryl.
Thank you, Patrick.
So this is our final session of the post-employment massive open online course. What are we going to be covering today?
Well, what I want to do first thing today is to sort of do a summary of what we discussed yesterday. We were walking through a set of facts that we had, a checklist for an employee that we had,
Right.
And we filled out a worksheet. And in going through it, we really tried to drill down into each of the elements. And so while I was trying to keep us sort of reverting back to and informing ourselves back to the actual example that we had started with, I just want to make sure that everybody sort of got everything we intended to have you get through the exercise yesterday. So we're going to start out with a summary of our findings in the exercise yesterday. And then we're going to open up the lines, the phone line, and we're going to ask people on Google Hangouts to ask any questions that you have from yesterday. We didn't leave enough time at the end of yesterday for you to ask any questions that you had, so we want to spend some time today answering those questions before we move on to our second exercise. So once we've answered any questions that you might have, we'll then move on to debriefing the second exercise.
Excellent. I think that sounds like an excellent way forward. Should we go ahead and open the phone line for any questions?
I want to do a summary first. So
Okay.
let me sort of reprise what we covered yesterday. Our exercise involved reviewing a post-employment checklist that we had for our employee Ken Dickens. And Ken was a regulatory counsel with the Food and Drug Administration, and he was a GS-15. So the first thing that we noted, because he was a GS-15, was that he was not a senior employee. So we knew that we could immediately eliminate 207C as a possibility, and we knew we were going to be limiting our analysis to 207A1 and A2.
Okay.
So once we decide we're only looking at 207A1 and A2, our first course of action is always to see if we can identify any specific party matters that the employee may have worked on during government service, because A1 and A2 are restrictions that are only going to reach to any specific party matters that the employee either worked on personally and substantially while a government employee, or that was pending under their official responsibility while a government employee.
So those are the things like contracts or grants, investigations, litigation, parties, or particular matters where you have named parties.
Exactly. So we looked through Ken's checklist, and he's done a variety of things. He drafted regulations, but the only thing that we've found on his checklist that fell within the ambit of the definition of a particular matter involving specific parties was an investigation of a pharmaceutical company, in fact, the pharmaceutical company being his prospective employer. And the investigation, his participation in the investigation involved providing legal support to that wellness investigation. So that was the specific party matter that then we honed in on, and we realized that any post-employment restrictions that Ken was going to have were going to be related to that specific party matter. So one of the questions for Ken would be, is this matter still ongoing? And presuming that the matter is still ongoing, the next question that we had to answer was, is there any likelihood that Ken is going to be doing any work for his new employer once he leaves government service that could be related to the same particular matter that he worked on, this wellness investigation?
So we're looking for a possible nexus between his proposed responsibilities in post-government employment and any specific party matters he worked on as a federal employee.
Exactly, because the communication bar that he's going to face under A1 or A2 is going to be related to, it has to be the same particular matter involving specific parties. And it has to have parties both at the time that he participated in the matter as a government employee and when he was engaging in the post-employment communication.
So if I recall from yesterday, he was involved in that investigation, and the investigation, one of the parties to that investigation was his proposed future employer.
Exactly. And again, while it wasn't clear whether or not that was still ongoing, we proceeded ahead in our analysis to be able to talk about what would his restrictions be with respect to that same particular matter. Because it does look as though he's going to have duties. He's going to be the point person for communications on compliance with regulatory requirements. So it looked like there was a very good likelihood that if this thing is still alive, he would likely be asked by Wellness to participate in that in some form or fashion.
Right, so we definitely wanted to look into that.
So we did. So then we walked through, okay, so what are his bars? He's prohibited from making a communication or appearance with the intent to influence, to or before an employee on the United States on behalf of any other person. And we walked through each of those elements and discussed a little bit what those restrictions would look like. So for instance, we would have to tell Ken that with respect to that investigation, he couldn't make any phone calls, he couldn't send any emails, he couldn't pretty much in any way share any kind of information or exchange or transmit any kind of information back to the government in connection with that same investigation of wellness. And one thing, 2 points that we tried to underscore there is that it's that communication bar reaches to whether Ken himself personally and directly does the communication,
Right.
or if Ken were to somehow use a third-party intermediary to make that communication on his behalf with attribution.
Right. So the idea that if the communication was meant to be understood to be from Ken, even if he doesn't do the uttering, we could have a problem.
Exactly. Now, Ken could confine himself to behind-the-scenes assistance on the same matter, but he would be prohibited from making any communication or appearance before the United States government on behalf of wellness in connection with this same particular matter. So that's sort of a reprise of what we discussed yesterday. So now I would like to, if the coordinator on the teleconference, if we could open up the phone line. So if anyone has any questions that you had from yesterday, and likewise on the Google Hangout, if anyone has any questions that you'd like to post, I'd like to take some time right now to be able to answer any questions that you have from yesterday.
And again, for folks on the Hangout, you can ask a question by using the question app in the lower right-hand corner of your screen.
Thank you. If you'd like to ask a question, please press *1. Record your name clearly. If you need to withdraw your question, press *2. Again, to ask a question, please press *1 at this time. Thank you.
We'll give folks just a couple
At
minutes.
this time, I have no questions right now
Okay.
on
Excellent.
the audio call.
Okay.
Thank you. We'll give folks just another minute on the Hangout because sometimes it takes a little bit of time to type in your question.
And while we're waiting to see if anyone has a question to post, I hope everybody, again, had a chance to take a shot at the next exercise. This exercise is a little bit different in a couple of aspects. Number one, it isn't a checklist. It's probably more often how many of you get your questions, your post-employment questions to you, which is just in the sort of a narrative from an employee in the context of an email. Our facts seem to be somewhat thinner in
Yes.
our email, which is what I'm sure that you all are accustomed to. So we wanted to sort of debrief it, like how do you sort of ferret through a little bit of information that you get through maybe some informal mechanism.
Yeah, when I was looking at this, I got the sense that the training wheels had come off, and that this may be a little more real life from my experience advising employees.
Exactly, and we're, as you could tell probably, I hope I'm not giving away the shop here before we start debriefing the exercise, but very early into that email, you can see that you're dealing with a separate provision from the provisions that we were dealing with yesterday. Yesterday we were dealing with A1 and A2, and today we're going to be dealing primarily with C. But the other piece was that with respect to Ken, there you were giving prospective advice. Ken hasn't left government yet, and he's asking you to tell him what he can or can't do prospectively before he actually gets out there and can run afoul of the law. Here you're having someone who's already left government service, who's already engaging in activities on the outside, and this is a little trickier because now they're in a position to actually violate the statute.
Yeah, but in some ways it's nice because we have the possibility to get more complete facts. We have more knowledge because there's a specific proposed activity now that the person is outside of the government engaging in employment kind of activities.
Right, because now it's not hypothetical. Now it's all very real. Okay. Well, it doesn't look like we have any questions from yesterday, but if any occur to you, at least for the folks on the Hangout, please do submit them as they're occurring to you. And for the folks on the phone, I will probably be opening up the phone lines again one or two times more, certainly at the end, but I may even try to open it up somewhere in the middle to make sure that that everybody's on the same page with what we're covering today.
Excellent.
So if you want to take us over to the deck, Patrick, That would be really helpful.
There we go.
So, as I said, when we look at the email that we got from Mary Carlile, and let's just all of us kind of like look through it to see what Mary has given us, and then we'll sort of launch from here into the deck. Mary says, you know, dear Janice, she's written the ethics advisor. I'm minding the advice you gave me before leaving the agency. I'm requesting advice. My service as chair of the government board ended on September 30th. So we know that this was the chairperson of a government board.
Okay.
I don't know about your experience, Patrick, but for me, anytime I hear chairperson of a board with respect to the government, more often than not, those are going to be fairly high-level
Usually
officials.
that's the case, yes.
If I recall my briefing with you correctly, I have some sort of restrictions I must abide by for 1 year from the date of my termination of service from the board.
It looks like we might have looked at this one before.
Yeah. So well, this is kind of, I think this is on some level might be good news, because evidently something stuck with this employee that they realized that they needed, A, that they had some sort of restriction for a year,
Right.
and B, that they should come and get advice before they actually did anything.
And they remembered how to do that.
Yes.
So, pretty good all around.
They're now on the board of directors for Keynesian Incorporated, and would like to schedule a meeting with Susan Proxel and John Gardner. They are at the board to discuss the comments Keynesian submitted in response to new guidelines recently published by the board for public comment. I'm certain there's no problem with scheduling a meeting. I only wish to know what, if any, limitations there may be on my participation at that meeting. It seems only courteous that I do some introductions, but beyond that, I'm uncertain what is permitted. We hope to have this meeting soon. Thank you in advance for your assistance, Mary Carlile. Okay, so there's good news in here in that we're even being asked for advice. So this
Right.
isn't like landing on our doorstep and then we have to deal with it in a post facto kind of way.
It's a little on the other side, because of course it's a matter of some urgency. These are always matters of urgency in my experience.
Yes, and hop to it, can't you, dear? Okay, so I think that we've decided that we probably are dealing with, I mean, we'd obviously want to confirm this, and you obviously would know if somebody's contacting you whether or not you're dealing with a senior employee. But we set up the facts in this scenario to make it fairly clear that this is what you are likely dealing with is a senior employee, okay? Now, having said that, does that mean that senior employees don't also potentially have A1 and A2 restrictions?
I don't think so.
No, it doesn't. It does not. But one thing I would advise you is, because C is a much broader restriction, and it's going to reach to communications about anything where you're seeking official action, and it's a 1-year cooling off period for your senior folks, that for your senior employees, I always hone in on 207C first, because they're going to be most restricted under 207C.
That makes a lot of sense. So for that 1-year period where they're covered by the restriction at C,
Right.
that's going to be the largest obligation not to communicate. And the restrictions under A1 and A2 would be kind of subsumed under that.
Right.
So we only need to become concerned about those after the expiration of the cooling off period.
Right. So just to remind everybody what we had reviewed that first 2 days ago in the sort of the overview of the 207C process. This is a 1-year cooling off period that begins at the termination of senior service. So when someone is a senior employee, that their senior service, termination of their senior service is the triggering event for the cooling off period to begin, and it lasts for 1 year from that date. And their restriction reaches to appearances or communications with the intent to influence, which is the same it's exactly the same definitions as apply under A1 and A2, and we talked about those yesterday. Where it gets different is it's a restriction on a communication to or before an employee of the senior employee's former agency.
So that's a little narrower. I think yesterday we were talking about basically any employee of the government with the exception of congressmen and their representatives.
Right.
But here we're talking about kind of the more common sense situation where it's people you used to work with.
Exactly. We have it's got to be on behalf of another person. So again, 207C doesn't bar self-representation, so it has to be on behalf of another person, as we spoke about yesterday. But here's where it gets really broad, because the restriction is on an appearance or communication in connection with any matter in which the former senior employee is seeking official action. So that's where it starts getting really broad.
So we're not just talking about contracts and grants and licensings and investigations. We're not even just talking about rulemakings that have an effect on a discrete and identifiable class. We're talking about any matter?
We're talking about any matter, and it doesn't have to be a matter that the employee worked on. It doesn't have to be a matter that was pending before the agency. It can be a brand new matter. It is truly any matter where the employee is seeking official action by the agency.
So this is kind of where we see that this is indeed a cooling off.
Right.
We're not talking about switching sides here. We're talking about remaining kind of incommunicado for a period to allow your residual authority to sort of diminish.
Right, exactly. So if we go to the next slide. Okay, there we go. Okay, so let's get into our worksheet here. Our worksheet for 207C. We're going to start with 207C, and time permitting, we can go back and talk a little bit about A1 and A2, but we're mostly concerned about C for purposes of today's debrief. So let's look at our worksheet for 207C. And the first question we ask, obviously, was the employee a senior employee, or is the employee a senior employee? And for our purposes, we're answering that question in the affirmative, and that's going to be our assumption moving through the rest of this exercise. One thing I do want to point out, and you do see it here on your slide, is that for those of you who have special government employees are only going to be subject to 207C if they served, well, first of all, if they meet one of the thresholds for being a senior employee, which is and it's typically going to be one of the pay thresholds, or maybe it's typically going to be a pay threshold that's going to trigger their senior employee status. But they also have to have served for 60 or more days during that period of being an SGE. So you're going to have to do a calculation about whether or not they served more than 60 days, and it's actually in the regulation itself too. So just so that you're aware that the regulation also gives you information about when an SGE is triggered, when that 60-day period is triggered by an SGE. So our employee is probably a senior employee by virtue of her pay grade.
Right.
Although it may be, it's probably that, or it could be that by nature of her appointment as well.
That's also, yeah.
So now we need to know, the next thing that we need to know is whether or not she served for more than one. She served more than 1 year ago, because the cooling off period only lasts a year. So one of the second thing you're going to have to ask yourself, which is the second question that we have here, is did the employee terminate service as a senior employee more than 1 year ago? And in our case, what does she tell us?
She said her service ended on September 30th.
So September 30th of
probably 2014.
Of 2014.
So we're approaching the year anniversary, but it looks like we're still within that time frame.
So we are still within that 1 year cooling off period. So we can proceed with our analysis, because she's definitely still within the 207C bar. So when we look at what she's planning to do or what she's asking to do with respect to coming back before the government, what is it that she says she'd like to be able to do in the context of?
Well, she says that their goal is to have a meeting with some agency officials, it looks like. She'd like to participate in the scheduling of that meeting. She'd like to know if there are any limitations on participation in that meeting, and particularly she thinks it would be nice if she could do some introductions at the meeting. So I kind of count 3 requests there. May I schedule this meeting? May I conduct the introductions at the meeting? And what other participation would be permitted for our employee to participate in at the meeting?
Exactly. So let's look at those 3 activities, because each of those activities we have to make a determination if in each of those cases that activity would constitute an appearance or communication with the intent to influence. Okay. Actually, before we get there, I want to sort of land on the slide that's before you. I want to kind of touch on that first, because at the end of the day, it looks very much like, in our case, we know that she's going to be making this a communication or appearance to or before her former agency. I mean, clearly she was the board person there.
Right.
From the email, it looks like, why do we even have to address this issue? So maybe let's start here just so that you understand. In our case, in our particular case, there's no question that our senior employee is making a communication before her former agency. But let's just clarify for some of you out there who maybe belong to departments where you have component agencies and things like that. I want to clarify a little bit what constitutes to or before your former agency, so that then we can spend more time talking about an appearance or communication, and we kind of have dispensed with the to or before an employee of your former agency.
Okay, excellent.
So
there's our question. What does it mean to... What is my former agency? How do I know where I used to work?
Exactly. And if we look at your former agency, if we get into the regulations themselves, it talks about, and we're going to be in a completely different provision of 2641 today, because we're going to be in 204. 2641.204.
Way over there.
Way, way, way over here.
I have it on page 687 at the bottom right-hand corner of the page.
Right. So what we're dealing with here is it's talking about to or before an employee of a former agency. And we talk about what constitutes an employee for purposes of that, like who's an employee of a former agency.
Okay.
And one thing to point out about that is, obviously, it's all the current, the actual full-time federal employees who work at that agency, but just so that you're aware, it'll also reach to any IPA personnel who might have been detailed to the agency. So you want to be mindful of the list of employees who are here under your former employees of a former agency. But let's go down to former agency, and it says, unless you're eligible to benefit from the designation of distinct and separate agency components, a former senior employee's former agency will ordinarily be considered to be the whole of any larger agency of which his former agency was a part on the date he terminated senior service.
Okay.
Okay? So now that's we need to understand. Well, actually, Patrick, what is your understanding of what these component designations are? Because there are a lot of departments and agencies that have what this regulation is referring to as component designations.
So it seems here, absent a component designation, we go to the largest possible categorization of former employer. Mm-hmm. But then we do have this ability for agencies to request component designations for purposes of 207C.
Right.
And I know we publish an update on this every year to update the community and update the regulations about who has those designations. Mm-hmm. But my understanding is basically it's a determination that OGE and the agency makes together that a part of a larger organization can be considered separate for purposes of this restriction.
Exactly.
So maybe like at a very large department that has many semi-autonomous components, they could ask for recognition of the component as the agency or the entity where this restriction applies.
Exactly. And and these are published in the Federal Register, and they are, as you said, they are updated every year. So agencies, it's not a static thing. Agencies, right. Departments and agencies can change their determinations or add additional component designations, or
and sometimes they take them away, I understand.
Or sometimes they take them away, right, as well. And I think for purposes of understanding how this works, effectively what the component designation does is it takes that component out of the larger superstructure of the department and treats it almost as if it were a separate agency for purposes of 207C, so that former employees of that particular component are only going to have restrictions with respect to that particular component. And I'm skipping you around in the slide deck here, but I think it's worth doing. If you go to slide 34, and we've got an illustration of component designations for 207C that we've taken. It's a partial representation of the Department of Justice's component designations. There are more components than this. We're doing this just for illustrative purposes.
Because we've probably heard of these components. Some of the others might not be familiar to folks.
Exactly. So the way this works is if you work in the main justice, and by main justice I mean like headquarters, like where the office of the Attorney General is, and okay, you know, if you work within that designated entity, then you're only going to have post-employment restrictions with respect to that entity, Main Justice and all of its constituent parts, and any other parts of justice that have not been enumerated as separate component designations. So for purposes of our drawing here, you have people in Main Justice only have a restriction with respect to that big circle in the middle, and then anything else that may not have been designated
as separate. So things are considered are assumed to be part of the whole unless they're designated as separate from the whole.
Right.
Right. So unless a component of the larger department has been designated as separate, if you're an employee of the main component or any component that hasn't been designated as separate, that's still treated as sort of one entity.
Exactly.
Okay.
Exactly. So that's why it's the big circle in the middle, because it's containing everything that hasn't otherwise been designated. Okay. But if you look at each of the constituent small circles, the FBI has a separate component designation, Bureau of Prisons, ATF, EOUSA. So what that means is senior employees who leave the FBI are restricted only with respect to communications back to the FBI.
Okay,
They are not restricted with respect to communications back to Bureau of Prisons, back to ATF, back to EOUSA, or back to Main Justice.
Okay, so that makes sense. So if I work for the FBI, my restrictions are contained to that component that has been designated.
Exactly.
Okay, that makes sense to me.
Exactly. So that's how our component designations work. Okay. So if you belong to a department and you're not sure whether or not you have separate component designations, you can look in Appendix B to Part 2641, and all of the component designations for any approved component designation should be enumerated in Appendix B to 2641.
But that also works in the other direction, is that right, Cheryl? So if I work at Main Justice and FBI has been designated as a separate component, my restriction doesn't reach to FBI because I'm not an employee of that component. Is that what I understood?
Again?
Yeah, sure. So if I worked at Main Justice and say the Office of the Attorney General, and FBI has been separated as a separate component, I don't have a 207C restriction with respect to the FBI because they're a separate component.
That's exactly right.
Okay, so
That's
it goes
exactly
in both
right.
directions. So separate really means separate.
Yes, it does.
In both cases. Okay, that makes sense to me.
Exactly. Okay. So that's the component designation piece in terms of what constitutes your former agency or what can constitute your former agency. But there's also another piece to it that I want you to look at, which is, it's, if we can get back to where we were with the former agency. If you look on 688 at the top of page 688, and we get back to 204, where we just ended, okay, it talks about what the one-year period before termination involves. So it says that how you decide who your former agency is, you have to do a one-year look back from your date of termination from senior service. Okay? So from your date of senior service, you take a one-year look back, and then you have to capture any agency where you served in any capacity during that one-year period prior to your termination from senior service. Okay?
Okay, I think I got it. So if I leave an organization as a senior official, I look back for the previous year to see who I have served.
Right, in any capacity, not just as a senior employee.
Not just as a senior employee, but in any capacity. So I spend, I don't know, 3 weeks, 2 months as a senior employee. I've had some other assignments before I assumed those roles. It was a brief term. I still look back a year and say, well, I was a GS-15 here before I became a senior employee. If that happened 1 year prior to my exiting the senior service, it counts.
Yes.
Okay.
I'm going to give you an illustrative example because this is the piece I think that's kind of hard to get your head around sometimes.
Yeah.
Okay. Okay, so our example is going to be we had an employee who started out as a GS-15 at USDA and was there until January of 2013. Okay, they leave USDA because they got a promotion, obviously, to the SES, so now they're a senior employee, right? So they get promotion to a senior employee status. They go to DOJ in January of 2013, and then they leave government in December of 2013. Okay? So we have to do a one-year look back from the time that they terminate their senior service, which is when they leave government service. So from December of 2013, we're doing a one-year look back to December of 2012. So where did this employee serve from December of 2012 through December of 2013.
So they certainly served at DOJ in their SES capacity as a senior official, but there were also at least a few days where they were also at USDA. So that the very, very first portion of that 1 year period, they were still at USDA as a GS-15.
Exactly. And the fact that they were a GS-15 is immaterial. If you do the 1 year look back from the time they terminate senior service, it captures any agency where the employee served during that 1 year period prior to termination. So in our example, this employee would have a 1 year cooling off period with respect, under 207C, with respect to both USDA and DOJ.
It's not going to be a happy employee.
No.
No.
No. But I just wanted to alert you to that, because in our particular instance, we wouldn't get to this piece because our employee clearly is just reporting back to their former agency. But a lot of other people have much more complicated or much larger organizations, and the agent and the what constitutes your former agency is quite different.
And this would apply equally to components, right? So if I served in the DOJ example, I spent a few months at BOP, and then I went to the FBI, and then I came to Maine Justice, all within that final year before I exited the senior service. All of those components would be captured for the cooling off period.
Right.
Okay, that makes sense.
Okay. Okay, so now I want us to go back to the litany of activities that you spoke of Patrick. The things that we have to actually look at in the context of whether or not they constitute a communication or appearance with the intent to influence. So we started out, and you said the first thing that our employee has talked about she wants to do is she wanted to call and schedule a meeting.
Right.
So calling two former employees that she clearly worked with, because she named who precisely it is she wants to call, did she not?
Yes, she did. She told us she'd really like to talk to Susan Proxel and John Gardner.
Okay, so she wants to presumably make a phone call or something to schedule a meeting. Do we think that very act of picking up the phone and calling these two folks and scheduling a meeting is a communication or appearance? We'll start just there.
Well, it seems like it must be a communication, right?
Right.
This person is directly conveying information to employees of our agency, so that would seem to be, under any normal understanding of the word communication, to be, in fact, a communication.
Exactly. So what about the intent to influence piece, though?
I think that's a little trickier, but it does seem that our employee is asking for something, requesting action by the government. They would like the government to send some officials to a place or make arrangements so that government officials can meet with some officials from this outside organization. And
if we look, I mean, when you look in the regulation, if you're looking under 204, it's gonna revert you back to 201 because that's the section that deals with 207A1, and that's because, as we noticed on our sort of flow chart of the process, a lot of these elements are common among and between various of the provisions. So let's just go back and remind ourselves under 2641.201.
Yes, I go back to page 671 in my book, so that's D. As we make a communication when the employee imparts or transmits information of any kind, including facts, opinions, ideas, questions, or directions. So I think we have a question here when we're asking for the meeting.
And I guess my thought would be, okay, so if we well, let's get to the intent to influence piece first, and then we'll come back to kind of, are there alternative ways of permitting this? So it is a communication. I'm talking over the phone, sending an email, anything where you're transmitting information is clearly communication. But let's look at the intent to influence piece.
So that's over on the next page.
It's on the next page, on 672, paragraph 2. Okay? Or paragraph 1, I mean, sorry. So it's communications or appearances made by the former government employee.
For the purposes, it looks like seeking a ruling, a benefit, approval, or other discretionary government action.
I think that's where we pick this up here. I mean, when someone wants to have a private meeting with particular decision makers in your organization, the decision to have that meeting, is that not a discretionary thing?
Absolutely. We don't accept meeting requests from anyone who calls us. We'll entertain meeting requests from any outside organization who requests them, but it doesn't mean that we will necessarily act upon them. And in fact, most organizations decline some of these requests. So someone has to make a decision about whether or not we are or aren't going to go forward with a particular meeting. So yeah, I don't see how we could say that isn't discretionary government action.
So I think that at the end of the day, just this very initial action of wanting to call and set up a meeting is something that she's not going to be able to do.
That seems sensible to me. And that seems also like the precise kind of thing that we're concerned about during this cooling off period, is the undue use of any residual authority or relationships a person might have.
And the fact that she sort of handpicked who it is she wants to call and get the meeting with.
Presumably because she knows these people from her prior employer, and she wants to use those benefits for the benefit of her new employer.
Okay. Well, let's do a couple of what ifs and see if we have a variation on this theme, if there's something else that might actually work. What if instead of Mary calling these two people, she has her executive assistant or another member of the board calls these people and asks for a meeting? Is that a problem?
I think it would be less of a problem, but maybe not necessarily no problem at all. I think the question we'd have to ask is, would that communication, would the recipients of that communication be meant to understand that that communication was in fact from Mary?
And this is where we get into, this is where the fuzziness of that sort of third-party intermediary concept, I think, really, they have to be really, really careful with it. I mean, I think that if some other member of the board were to call and to request a meeting and make absolutely no reference to Mary whatever,
we're probably okay.
You're
there.
probably okay. I don't think that Mary's having a restriction should entirely cripple her organization's ability to communicate with her former agency.
But if Mary's assistant, say, were to call and say, "This is Patrick Shepard. I'm Mary Carlile's assistant. She asked me to call you to set up a meeting. I understand you guys work together, and these days would be really good for us."
That, I think, is problematic. Whenever it's a situation where somebody else is making the phone call, but they are invoking Mary's name or otherwise making reference to Mary, such that Mary now has been brought in as the source of the initiation for the phone call. I think that's where you're getting into the land where I think that now you're looking at a third-party intermediary communication.
And I think where it gets tricky is if another board member called and said, Mary Carlile gave me your number and suggested you'd be a good person to reach out to, it would probably be best to avoid that activity. How that would actually break out in the courts is probably anyone's guess.
Well, and this is where I think it's useful to take a minute and talk a little bit about behind-the-scenes activity here, because there's nothing wrong. There is nothing in the statute that says Mary can't tell board members who are the appropriate people to call, or for a whole host of things that Mary can't say, this is the person who knows this or this is the person who knows that. Behind-the-scenes information sharing, behind-the-scenes activity is entirely permissible under 207. The problem is when that it doesn't confine itself to behind the scenes, such that whether intentionally or inadvertently, in the context of a communication, people that Mary works with start, again, dropping her name, suggesting that she's the one who gave them information to call. Anytime you start bringing that communication back and identifying it with the former employee, that's where it gets problematic.
I think that makes sense. And again, with what we're trying to prevent with this rule, it is the undue use of residual authority resulting from federal employment for the benefit of outside parties. And that's exactly what you would be doing if you were the board member calling and saying, Mary thought it would be great if you took a meeting with us.
Okay. So we think scheduling a meeting is going to be a problem for Mary if she's the person who's actually on the phone scheduling the meeting. So if scheduling a meeting is going to be problematic, so let's move on to what about if she actually sort of attends the meeting?
Okay. So we get over the meeting scheduling hurdle. Maybe we have someone else at the organization request the meeting and not make reference to Mary, but now she's going to attend the meeting. Well, I think that's going to be tricky, right? Because we're going to have to determine whether or not she's appearing before or making a communication to. And I think it's going to be tough to attend the meeting without making an appearance. Is that right?
And this is where we get into that sort of, okay, well, what is Mary contemplating doing in this meeting. Now, I think Mary wants to have an active role in this meeting. I think she's made that pretty clear. At the
Yep.
very least, she wants to do introductions, and she doesn't even think making introductions is problematic.
Right.
Okay. So I think we're dealing with, first, initially, can she even appear in this meeting? Okay. I think we just need to start there. Because we have this notion that I talked a little bit about yesterday and said we were going to spend a little bit more time on. This notion that you can appear, say absolutely nothing, and still be deemed to be appearing with the intent to influence. So this part is on page 673 if you're using the blue book. It's at 2641.201 E4.
Yeah, that's what I remember from yesterday.
And it says mere physical presence intended to influence, okay? So if we look here, Patrick, what does it sort of seem to be? I mean, they give us a lot of factors here, but what is your sort of understanding about this whole provision?
So it looks like it's possible to, just by merely physically being present, that your appearance can be viewed as an intent to influence. That we don't actually have to say anything. So,
so there's some indicia here.
Right.
I mean, the thing I want everybody to understand here is we've given you indicia because this is one of those things that's going to be hugely fact-based, and it's going to be hugely a matter of what the former employees. Well, let's walk down through the factors a little bit so you can get a flavor for what it is that we think has to be present, or things that,
exactly.
if they are present, would probably be an appearance with the intent to influence.
no, I think these are very interesting. So the former employee has been given actual apparent authority to make any decisions, commitments, or substantive arguments in the course of the appearance.
So even if they're not making those decisions or doing
Right.
it actually physically in the room with you, the fact that there's any indicia that that's going to be their role.
Right, that they're in a decision-making capacity for the organization. They're understood to have authority in with respect to these matters.
Yes, and I would say if they have that, and there's every indication that they have that, then they're also probably looking like they've been they're probably sitting there very uncomfortably, like practically bursting at the seams, hoping that they can weigh in.
Right. There's a lot of signaling. Lots of thumbs up.
But the idea being that if it's very clear that among the people in that room, this is a person who's a mover and shaker, this person is a decision maker, that notwithstanding that they are not saying anything, they clearly are in a position to be making decisions based on whatever's going to occur
and here
in that meeting.
we ask folks to consider the former employee's presence, the prominence of their presence at the meeting or other event. So if they're introduced, or if it's expected that everyone will know exactly who this person is. They're sitting at the front of the table, but they are just not going to say anything. That's maybe not going to get us there.
Right. I think the next one is kind of reaching then over the aisle to say who from the government agency is going to be there.
Right.
So are there government employees there who actually are in a position to be making decisions? Because, and this I think is trying to reach to the fact that if for whatever reason this is a purely ministerial meeting where there's no ability for the person who's the government employee to have any authority to do anything, then that mitigates a little the argument that there's an intent to influence, because you can't influence somebody who has no authority to do anything.
To be influenced, right?
Right.
They're not able to make the decision. So if there's no sort of pending action, or there's no one there who can act on government action, then maybe we don't have an intent to influence.
Another consideration, and these aren't necessarily, they don't necessarily all have to be present, but these are all just separate indicators of things that you would want to take into consideration. If the employee's being paid for making the appearance, paid for making the appearance, then and on some level the assumption is that their presence there is of importance to the people who sent them.
Right.
So that's another indicia. If they start making references. The next one is if you're making any references to the views of the individual, talking about them in the third party as if they're not sitting there.
Like, you remember when Mary wrote that very interesting article that said the following things, and Mary just sits there quietly and nods her head.
Although the nodding itself might be a communication.
Right? Conveyance of non-verbal information.
The next one is that to make that it's clear that the person is there not just merely to collect information, so that there's an alternative purpose for them being there.
So this would be like in the case where maybe there's a large open public hearing, and we have a former employee who's been sent there to sit in the back and take notes.
Right.
Right. We might say that sitting in the back and enjoying the speech or taking in the information the government's communicating wouldn't necessarily be in appearance with the intent to influence, right? Because the person delivering the information might not be contemplating any action.
Right.
Right. Their obligation is to deliver information, and this person is there merely to, sort of document that information and take it back to the organization.
Right. Right. The next one is the former employees entered a formal appearance in connection with a legal proceeding at which he is present. I think that one sort of is self-explanatory. And the last one, which is the appearances before former subordinates or others in the same chain of command as the former employee. And I think this one really reaches hugely, I think, to the whole reason we have this senior employee restriction, which is that vestigial sense of authority that you have over people that you used to have.
Right. So, if you're the agency head and you're going to go sit in a meeting with your former deputies and give them stern looks to encourage them to agree with your new employer, that's the kind of things we're concerned about.
So if we take that kind of litany of indicia and we apply it to our set of facts. So here we have this person was the former chair of this agency. She wants to come to this meeting where they're going to be discussing the comments that her new employer submitted in response to some guidelines that had been published. Do you think that Mary sitting in the room, imperiously without saying a word could reasonably be construed that Mary's there to cast some sort of influence over the proceeding?
No, I think that's an interesting question. And I think, it's very possible that we could have a situation where the goal of her attendance is to, in some ways, attribute or suggest the authority of Mary is complicit in delivering these comments, right? Because the comments themselves are kind of advocacy, right? They're almost a request in themselves. And if we're discussing those and Mary's attendance is there to bolster the case that this organization is making with respect to these matters, I think there's a danger there.
I would agree. I don't think that there's any question that anyone in that room, particularly you're looking at, it's not been quite a year, and Mary was the chairman of the board, and I'm sure people in that room are very aware of what Mary's opinions were on this, because presumably this was something that may very well have been in the works while Mary was chairman of the board. So
yeah, and I always like to think about what other reasons the organization might have for bringing Mary along, right? And in this case, it doesn't seem like they want Mary to take notes. She's not there to capture the minutes, right? The likelihood is that they're bringing her along because she used to work at our agency, and she would like us to feel the residual authority that comes with being the former chair.
And she also wants to project that authority to her new employer. Without meaning to be too heavy-handed, but to sort of capitalize on the fact that she was an important person in this organization, and she can get them access and
I think when she discusses the making of the introductions, that's sort of an indicia that that's exactly what we want to do, right? I want to use my previous relationships and transfer them to my new employer.
Right.
Yeah.
Right. So I think that there's no question in this instance that her appearance, even with absent a communication, would be an appearance with the intent to influence. Okay. So frankly, we don't have to move much beyond that. It's really, Mary, you cannot call and schedule the meeting, and neither can you attend the meeting.
Okay. I'm comfortable with that.
Now, one question that I always get whenever we do this class is, what about, we now have conference call capabilities. We have people who are on the phone right now who are anonymous to us right now because we don't necessarily know who is on the phone. And we get this question all the time. Well, what about if a former senior employee is in a conference call type of situation?
Okay.
They're on the line, but nobody knows they're on the line.
Okay.
And what are your thoughts on that, Patrick? I have my own thoughts on that, but I'd like to know your thoughts on that.
So the former senior employee is on the call,
Right,
but no one knows that they're on the call.
right.
Are they planning to speak on the call?
No.
No, they're not going to speak on the call. They're just going to be there listening. It seems to me that might be analogous to the situation where the person is going to maybe a public meeting and taking notes. Though there's a danger here that they could be tempted to speak,
Right,
or someone could be tempted to speak about them.
right.
I've been on conference calls where I wasn't supposed to participate. I was just listening. Something comes up that's in my area of expertise. And someone says, I know that Patrick's on the call. Patrick, do you have any thoughts here? Or you tend to agree with me, right? So it's not without risk, but I think, merely being there, taking in the information, maybe isn't problematic.
Right. I mean, I do think that in order for there to be an intent to influence, it seems to me that there has to be some understanding that the something has to be attributed to the person. And if there's no awareness that the person is even there, I don't know how you can attribute any intent to someone that you were not even aware that they were there.
Right.
So I'm inclined to say that I don't think that in and of itself would be sufficient. But at the end of the day, I'm with Patrick on this, which is that's a very dangerous place to be. And a lot of folks said it just seemed there was just something kind of about it, and the sort of like the surreptitious sort of like stalking or something kind of thing. But I do think at the end of the day that if their presence is not known, I don't know how you could ascribe an intent to an anonymous.
And in certain industries and certain kinds of work, it's not uncommon to have conference calls with hundreds or more people on the line. Today we probably have 100 people listening in at least. And to say that you couldn't join in the receipt of the information being transmitted during those fora seems unnecessarily restricted, provided that you don't in fact move into the area of making a communication.
So really, I think that at the end of the day, what we're looking at with Mary is that she's within her cooling off period, and that she simply can't do the things that she's asking her ethics official that she can do, which is she cannot make the telephone call to schedule a meeting, and if she allows somebody else at Keynesian to do it, she needs to make them know that they can't be invoking her name.
Right, that makes a lot of sense.
Although I think once she's broached it this way now, it's going to make it harder for Keynesian to do that without, and she certainly can't attend the meeting, even if she's not planning to say anything in the meeting.
And I think it's interesting here because you make a good point that we might already be in some difficulty. The fact that this question's come to us might cause some trouble for Keynesian. And that maybe when we're giving the initial advice, if we anticipate situations like this coming up, providing some quite specific guidance about these kinds of eventualities. So if this was sort of foreseeable from our perspective when Mary was leaving, it might have been helpful to her to say, for example, you can't call and request a meeting, because you could see this happening another way, where Mary's already called and asked for the meeting, and someone comes to us and says, Mary used to work here, she called me and asked for a meeting, is that okay? That's a much less fun position for us to be in.
And I think particularly with your senior employees, as you were saying, Patrick, I think particularly with your senior employees, since you don't have to attach it to anything they worked on, you don't have to have that additional sort of set of facts. I think the more like 4 instances that you can give them about like things that just are forbidden, the better off you are. So I think always giving your senior employees illustrative examples of what it means to like what that cooling off period actually entails, I think is really helpful.
Because we've spent probably 30 minutes or more talking about appearance or communication with the intent to influence in these various contexts. And that's a lot of detail to get your head around, particularly for a senior employee who's maybe not going to think about this for another 11 months. So if you can give them concrete examples in your guidance, that might be a little easier for them to digest and act upon than simply saying you cannot make an appearance or communication with the intent to influence, because I'm just asking for a meeting.
Right.
Right.
Well, one thing too is it's really useful to let your own employees, your current employees in your agency, also know that they can't be reaching out and making post-employment communications with these senior employees lest they pull them into a post-employment communication violation. So just because the government initiates the call doesn't then
resolve the issue from
resolve
the
the
employee's
issue from the
perspective.
employee's perspective. If the employee responds to that communication and they're doing it on behalf of a third party, they could be engaging in a prohibited communication under 207.
Right. We want to avoid that. So it's good to cover these restrictions both for the benefit of employees after they leave government service, but also so that they can assist current former employees with complying with these restrictions.
I wanted to open up the lines for questions about what we've covered so far. The next thing that we're going to cover after the question period is I do want to get into some of the exceptions and talk about some of the exceptions and waivers a little bit. We didn't get to those yesterday, and I think there are a few in particular that I really would like to highlight in connection, particularly with 207C. So if we can open up the lines, and folks on the Hangout, if you have any questions.
Yep. And again, on the Hangout, you can type your question in the lower right-hand corner of your screen.
At this time, if you'd like to ask a question, please press star 1. Record your name. If you'd like to withdraw your question, please hit star 2. Thank you.
While we're waiting, I've found this to be really helpful, the approach that we've taken over the past 2 days, because I've always found 207 to be confusing because there are so many different restrictions and they share common elements, and I start looking at the elements and I get confused. But I think taking it an authority at a time is very helpful, considering these are sort of separate analyses. You could almost imagine them as being separate laws that we just have to consider in sequence. Helps to keep things organized, in my mind at least.
And even within separate provisions, I mean, as you saw even today, it's very easy to lose your way. It's
Yes.
very easy to get off on a tangent on a particular aspect of a provision and then kind of, lose sight of where you were and lose your place in your analysis process. So again, I would suggest to you all, even if you didn't find this particular worksheet that we used helpful for your purposes, I mean, we all analyze differently and
Right.
think in different constructs, but to come up with something for yourself so that it will assist you when you're trying to make sense of facts and parse through them and decide whether or not all of the aspects of the provision have been met.
All right, and I'm not showing any questions on the Hangout. And
At this time, I have no questions on the audio call as well either.
Okay.
excellent, thanks.
Very good. Okay. So before we leave our analysis, I mean, we've decided that we think there are 207C restrictions with what Mary is proposing to do.
Right.
But before we can leave that, we need to make sure that there aren't any exceptions or waivers. Because like all good laws, there's
always
there's
exceptions.
always an exception. So I'd like us to take a look, get into the final subpart, and subpart C, I think it is, of 2641, and take a quick look at some of the exceptions and waivers. And we're gonna dig into a few of them, the ones that I think that are most commonly relied upon. But just so that you've got a sensibility about and about where to look and what these are pretty much gonna say.
Actually, sure. It looks like we've had a couple of questions
Oh, okay,
come
great.
in
Good.
over the Hangout.
Okay.
So the first question is, what happens when the former senior employee does violate C but is not discovered until more than a year has passed? Is there still a duty to report?
Anytime that you are aware or someone is aware of a violation of law, there is a duty to report.
Right, and that's for all federal employees,
That's
not
for all
just
federal
for
employees.
us
That's
as,
not just
as,
ethics
as ethics
officials.
counselors. So, if you see a violation of Title 18, you have a duty to report that to the appropriate official.
Yeah, and it depends on who what your protocols are at your agency. I would go to your IG. If you have an IG, I would report it to the IG.
And they'll be able to tell you if they're not the proper recipient for that information, and if you need to go directly to the Department of Justice, they will tell you. For agencies that do not have an Inspector General, that's also a possibility, is to go directly to DOJ. But generally, the IG, if you know who that is the best place to start. That's a good question.
Okay.
All right, we have another question from Michael Hoyle, and I think this is another timing question. If Mary is asking now for a meeting in October to coincide with a business meeting she has in D.C., do the issues of communicating or appearing with an intent to influence still exist? So we're asking within the year for an action that will be realized after the year has terminated. What's the important date? Is it the date that we make the communication, or is it the date where the issue may or may not be resolved?
Well, I think that there are two things. If you're asking for the meeting now, but the meeting isn't going to take place until October, asking for the meeting now, you're still within the 1-year cooling off period. So that is still clearly going to be prohibited,
right,
because it's still within the 1-year cooling off period. The question of if somebody else asks for the meeting and now we're outside of the cooling off period, so the meeting is actually going to take place in October, we're outside of the cooling off period, then technically, yeah, she's outside of the 1-year cooling off
right,
period, and she could attend that meeting.
We'd also want to be mindful, though, of any 207A1 restrictions, though, in that case, right? So,
Yeah.
that doesn't, just the fact that the 1 year has elapsed doesn't mean for our senior folks there are no more post-employment concerns at all. It's just that these ones at 207C are no longer a concern for us.
Exactly. So once we're outside of the 1-year cooling off period, now we're going to have to really dig down into, okay, what's going to happen at the meeting? What is going to be the subject matter of the meeting? Are there going to be any things that are going to be discussed that involve any particular matters involving specific parties in which she participated personally and substantially, or that were pending in the agency during the last year before she left service? So I think that the answer to that question is not quite as does her 207C restriction go away after September 30th? Yes.
Yes.
But that doesn't mean she doesn't have any post-employment restrictions.
Right.
And it certainly doesn't mean that she can go ahead and schedule the meeting during her cooling
Right.
off period.
Yeah, because it's when the communication takes place, or when the appearance takes place. So no appearance or communications within the year. Okay, I think that makes sense.
Yeah. good
Excellent. Thank you
question.
for your questions.
Very good questions. Okay, so if we look at the first one, I like to talk about the first one because I think it's curious in a lot of ways. The first exception in 2641.301 is an exception for acting on behalf of the United States. Now that seems rather queer, does it not, Patrick? That you would have to have an exception in a statute for somebody to act on behalf of the United States.
Yes.
It is. It's very.
It is a little unusual. I think I would have assumed that was implied, but I guess.
The interesting thing, though, is that once you get into the definition of what constitutes acting on behalf of the United States, you realize how utterly limited it is.
Okay, so this is maybe an exception that is actually a clarification of the breadth of the restriction.
I would say that.
Okay.
Yes. So, for purposes of this exception, on behalf of the United States, an employee is deemed to be acting on behalf of the United States. If we get down to paragraph 2, there are only 2 circumstances in which a former employee is deemed to be acting on behalf of the United States.
Okay.
In the first little paragraph, one little I,
If we're acting as...
an employee of the United States.
That makes sense.
Okay.
So if I'm working for the government, I'm acting on its behalf. Mm-hmm. Okay.
So a former employee engages in an activity on behalf of the United States when he carries out official duties as a current employee of the United States.
Okay. So if I swap agencies.
Yeah.
Okay.
Exactly. Or if you come back and you're rehired as an SGE or something, but somehow you're an employee of the United States.
Okay.
Okay? As other than an employee of the United States. Okay? So provided that you don't violate 207F.
Okay. So.
Okay.
It's the foreign entity.
Okay. You act as other than as an employee of the United States, you're acting on behalf of the United States. If you're representing the United States pursuant to a specific agreement with the U.S. to provide representational services to the United States.
Okay, so if we have an agreement other than an employment agreement to provide representational services to the United States, so if the U.S. government hires me, say, as their attorney. Mm-hmm. Okay.
So if the U.S. hires outside counsel,
Right.
you can provide that counsel.
Okay.
Now, you can't be the person negotiating that agreement.
Right.
The negotiation of that agreement is not representational services. That's a different set of services, so you
Right.
couldn't do that.
But under the agreement,
Under the agreement,
I could make representations as necessary.
you could provide the representational services as necessary.
Okay.
Okay. So then you're be acting on behalf of the United States.
Very good.
And the second instance is if you're a witness called by the United States, including a congressional committee, to testify at a congressional hearing, blah, 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 even if applicable procedural rules do not require him to declare by oath or affirmation that he will testify truthfully. So even if you're not under oath, if you're called as a witness by the United States, including a congressional committee, to testify at a congressional hearing. Okay?
Yep, that's pretty narrow. That's not a lot of circumstances.
That's it.
So this isn't if the U.S. agrees with my position, I'm working on their behalf, or if we have a similar position. It's literally I have to be carrying out my duties as an employee, or secured under some agreement to provide representational services to the government,
Right.
or at a congressional hearing where I've been called to testify.
Yes.
Okay, that's not many.
And if you go to paragraph B, it tells you what it's not, pretty explicitly. And it says, an former employee will not be deemed to engage in an activity on behalf of the United States merely because he's performing work funded by the government. So that's that circumstance where just because you're working for a contractor and the contractor's supposedly doing the work of the government, communications back to the government in that context are not on behalf of the United States.
Not on behalf of the U.S. Okay, so if I'm work at a lab or under contract, something like that, that's not enough.
Because he is engaging in the activity in response to a contact initiated by the government.
So this was your example from before. So if my former colleague calls me and asks me a question and I answer the question, that doesn't mean I'm doing that on behalf of the federal government or on behalf of the government. I'm still in trouble.
Exactly.
Okay.
Because the government will derive some benefit from the activity.
Oh, this is because we would like it if you did that, you may do it portion. That doesn't fly.
It doesn't fly. So even if the government would like you to come talk to it, the government doesn't have the authority to allow you to come talk to it.
Right. The government can't give you the authority to come make that communication.
Or because he or the person on whose behalf he is acting may share the same objective as the government.
Right. So the allies.
Yeah, we're all in the same boat. We're all doing this for the benefit of the United States.
We all want this project to work, whatever. That's not enough.
And explicitly, we say that in the regulation. Explicitly, those do not constitute acting on behalf of the United States.
And we have a whole bunch of examples in case we need further clarification.
There are tons and tons and tons.
But I think you're right. The big takeaway is that those are fairly narrow circumstances, and it's pretty clear when you are acting on behalf of the government.
Yes. So if someone comes to you and sort of wants to make that kind of argument, just make sure you make reference right back to this, because this will help you in making that argument to that employee.
And not only do we tell you those few circumstances in which you are acting on behalf of the U.S., we also give you a good sense of what it means not to act on behalf of the U.S.
Yes.
Yeah.
Yes.
Okay.
So the next one I want to take a quick look at is B, which is the exception for acting on behalf of state or local government as an elected official. I don't know how often this comes up, but I think it is important, particularly with some of our senior folks who are politically active people, that they may very well wind up in post federal government employment, being elected officials in state and local governments. And this exception basically allows people to engage in post-government employment communications that are undertaken in carrying out those official duties.
And I think this one makes sense, because otherwise this would sort of covertly function to deprive voters from their prerogative to have the people that they would like to have represent them for purposes of elected state and local office. Okay.
The next one is a really big one, and for those of you who have scientific and healthcare related and education-related types of employees, people who are likely to go on to medical research facilities or universities. This is a huge exception that comes into play for your senior employees. Now, this exception is only going to apply to your senior or your very senior employees. So this one isn't going to be eligible for like an A1 or A2 restriction.
Okay, so this is just, actually it says right here, 204 and 205.
So the specific entities that are indicated here are an agency or instrumentality of a state or local government. So here, kind of like we said with elected officials in B, this is going beyond that, and it's saying if you have a former senior employee who's just going to work for a state or local government, it's going to extend that same sort of like exception or waiver of their communication restriction.
Okay.
The next one is a hospital or medical research organization, as long as it's a 501c3.
Okay, so charitable hospitals or research organizations, we don't have to worry about the 207C and D restrictions.
The next is an accredited degree-granting institution of higher education, but it has to be one that meets the definition in 20 U.S.C. 1001.
Okay.
Okay. Now, these things sort of apply automatically, so it's not something that you have to exercise discretion over. These are going to apply. The thing that I do want to make sure that you're very aware of, though, is that paragraph 2 piece. The the position that they must hold with these outside organizations and the sort of like the condition in which they must be coming back and making those communications has to be as an employee of one of those specified entities.
So the relationship between the entity and the employee has to be one of employer-employee.
Right.
So not other things, not representative, not consultant, not spokesperson, unless that constitutes an employer-employee relationship. Okay.
Because it says explicitly in paragraph 2 at the very end, it says the term excludes an individual performing services for a specified entity as a consultant or independent contractor.
Okay, so you can't be sort of the hired gun representative, but if you're employed by them and your employment requires these kinds of communications, you're not barred.
Yes.
Okay.
Yeah.
Well, I think that makes sense because, it would be kind of an accident of your position that you'd be required to do this as an employee, whereas you might be actually profiting directly from your prior position by acting as a consultant or independent contractor, making representations on behalf of whoever wants to hire you. Okay, that makes sense to me.
The next one I want to take a look at, again, is sort of along the lines of what I was mentioning before for those of you who have scientific or technological types of folks, and that's E. This is an exception that sort of allows the government to retain access to people who have very specialized knowledge.
Okay.
And if you're going to avail yourself of E, though, I think you have to have procedures in place to invoke E. So that would be one thing that you're going to want to look into. And if you're going to use E, is establishing some procedures for utilizing that.
And if you're at an agency that does a lot of technical or scientific work, those procedures might exist. You might just have to go find them.
What I'd like to point out about this exception is what we mean by scientific and technological information, because you can call it that, but it really does, we do want to give you some semblance, and the regulation does try to provide some parameters for what falls within the ambit of scientific and technological information. So if you look at E2, it says, must convey information of a scientific or technological character, such as technical or engineering information relating to the natural sciences. The exception does not extend to information associated with a non-technical discipline, such as law, economics, or political science.
Oh, the
I am not going to apologize to anybody out there who's offended, whose sensibilities are offended because we think that law, economics, and political science are non-technical.
I know some economists who would disagree vigorously with this characterization.
But it is to let you know that that is the intent of this exception. It is meant to be limited to hard science, data type of information that's being
I had a friend
conveyed.
who was a political scientist, and he said it's so much a science we had to put it in the name there.
So those were really sort of the key pieces I wanted to highlight with these, is one, that you have to have procedures, and two, that there is a sort of like a definition of what types of information are really intended to be accepted under this exception.
Okay.
And the final one I wanted to touch on, just because I'm sure that a lot of you, when we got to that piece in the representing on behalf of the United States that said it's only if you're being called to be a witness in a congressional hearing, I could hear the wheels turning, I'm sure, some people saying, well, wait a minute, what about other kinds of testimony?
Right.
And F is where you get that. We have another exception for testimony that's made under oath or penalty of perjury. So this one is basically saying, obviously, if you're called as a fact witness in some sort of an adjudication, administrative or judicial proceeding, that you certainly can give that testimony under oath. What I like to call people's attention to, though, is the limitation when it comes to expert witness, because this is something we get a lot of questions about.
We do, yes.
The limitation on exceptions for service as an expert witness does not negate the bar at 207A1. So basically it's saying that if you are 207A1 restricted, you can't give expert witness testimony. Like the thing we've carved out here for expert witness testimony would not reach to an A1 restriction.
Right.
Okay? So, and it has to, the only way you can use it is if you've been called as a witness by the United States by court order, and for this purpose a subpoena is not considered to be a court order to testify as an expert witness. So it's a very limited carve out for expert witness testimony, and you can't use it if you're A1 restricted.
Okay.
Okay? So those are the ones I wanted to point out because those are the ones you're most commonly going to use and the ones you should be most aware of. But getting back to our Mary Carlile, was there anything in there that you heard that would make you believe that she could make that communication?
I do not see any exceptions that would seem to apply to the things Mary's proposing to do. In fact, the things Mary is proposing to do seem like exactly the types of activities that we are endeavoring to restrict with this provision.
Mm-hmm. So, I mean, unless this Keynesian organization, but it's Inc., so it's not a 501c3, unless it had been some sort of like a nonprofit
Right.
Medical research institution or something like that, I think we're fairly safe to say this looks like it was a corporation and there's no exception for Mary in that. So we talked about the exceptions. If we can go back over to this.
Sure, we can pull the slides up.
Yeah, that'd be great.
we go.
Thank you. We talked about the exceptions in the waiver, so I just always like to remind people to take a look at those before you decide that there's a restriction. But I also want to talk a little bit now about the pledge, because Mary was likely an appointee who signed the pledge. If she's a senior employee and she was a political, then she likely signed the pledge. So just to remind you that in addition to her 207C restriction, which is a one-year restriction, she's a former senior employee who signed the pledge, so that self-same restriction is going to be extended to a second year from the date that she ceased to be an appointee, which would have been the same date that she ceased to be a senior employee. So we're still looking at that September 30th deadline. So now she's got a two-year restriction. What I like to remind people of in this, though, is that only the first year is a criminal restriction. The second year is under the executive order. So the penalties would not be the same if there were to be a violation under the period of time where it was only covered by the executive order.
Right. So if we went back to, I believe it was Michael's scenario, where we request the meeting during the first year and hold the meeting during the second, we'd have a criminal problem with the meeting request and then administrative problems with the meeting attendance.
Yes,
Yeah.
exactly. For purposes of Pledge Paragraph 5, for the remainder of the administration, she would not have been allowed to lobby any covered executive branch officials or non-career senior executive service appointees. Now she would have it, and anybody else who signed the pledge would have it. Pledge Paragraph 5 isn't restricted just to senior employees, it's to any employee who signed the pledge. And just for your own purposes, covered official is a term that is defined in the Lobbying Disclosure Act.
Right.
So if you're looking for that definition, you can find that in the Lobbying Disclosure Act. That defines what constitutes a covered official. Okay. There are exceptions to paragraph 4 of the Ethics Pledge, and they incorporate all of the exceptions in 207C. So if there's an exception that would allow the person to do it under 207C, then that would also take care of any pledge restrictions.
So it literally just extends it for an extra year.
Right.
All restrictions and exceptions included.
Okay. Paragraph 5 doesn't have any exceptions, but evidently there are exceptions to the definition of lobbying contact. That's, again, in the Lobbying Disclosure Act. So you can avail yourself of those exceptions because it would carve certain activities out as not being lobbying for purposes of paragraph 5.
So it's possible that there's a communication that isn't a lobbying communication.
Right. Before we just give you the summary of that, one thing I did think you all might be interested in knowing is the example of Mary Carlile that I gave you actually was based upon a case that is in OGE's prosecution survey from 1993.
Okay.
So this was a case where it was a former employee who resigned her position on the Board of Governors of the Federal Reserve.
Okay.
And following her resignation, she was elected to the Board of Directors of a bunch of different companies. And on the behalf of one company, the company was affected by a guideline that was being issued by the Fed and other bank regulatory agencies. And the agencies, including the Fed, requested public comment on this guideline that they issued, and this new employer had written comments to the Fed. And then the officials of this organization, where she now was on the board of directors, met with members of the Fed's Board of Governors. and she attended that meeting. She arranged the meeting, and she attended the meeting. And she introduced the officials to the members of the boards of governors, but said absolutely nothing during the substantive part of the meeting. So this was one of those cases where, now maybe calling and requesting the meeting in and of itself was sufficient to have, implicated 207. But, she went to the meeting, introduced, and then sat down and said nothing for the rest of the meeting. And the organization paid her for her participation in the meeting. What she agreed to pay was a $5,000 civil fine in connection with an agreement to resolve the criminal investigation by the Public Integrity section about whether or not she had violated 207C. So a complaint for civil penalties was filed for a violation and dismissed in accordance with the settlement agreement. So basically, she had a settlement agreement, but this was something that was prosecuted by the Public Integrity section at the Department of Justice. So this kind of stuff really does happen,
right?
People. This isn't just theoretical.
No, and I think, when we're talking about making appearances and communications, these are things that are often detected, right? Because, you're actually doing it. It's the sort of thing that people observe.
So we basically covered the three primary sources of post-government employment. We introduced the regulation, and we did more than introduce it. We got you into it.
We read most of it.
We read most of it. We gave you a process to use that hopefully you'll find practical and useful. And we talked about how you go about trying to give some prospective advice. So we'd like to open it up one final time for any final questions that any folks have. So if we could open up the phone lines again, and again, folks on the Hangout, if you have any final questions, we'd be happy to entertain them before we call it a day.
At this time, if you'd like to ask a question on the audio portion of the call, please press star 1 and record your name clearly.
And again, a reminder for those on the Hangout, you can ask a question by typing it in the question box in the lower right-hand corner of your screen.
One thing I do like to remind folks is that if all of your employees who are subject to 207C are also subject to 207F. So, and 207F basically is reaching to circumstances where your former employee might be going to work for a foreign entity. It's a restriction on communicating and providing assistance to a foreign entity. So if you have someone that you think might be possibly doing that on a consultancy or other basis, make sure you're giving them 207F advice in addition to 207C. And the key piece, one of the key pieces with 207F, well, two of pieces. One, it reaches to behind-the-scenes assistance. So it bars not only communications and appearances, it also bars behind-the-scenes assistance. And it also applies to members of Congress. So it bars communications appearances to or before members of Congress. So it's a much broader restriction, but it's limited only to the services that you're providing or circumstances where you're providing services to a foreign entity.
Excellent. Well, that's always a good reminder because it's an easy one to forget.
Mm-hmm.
And I'm not showing any questions on the Hangout just yet. While we're waiting for any questions, I'd like to remind everyone listening on the phone and also on the Hangout that you will receive a course evaluation at the conclusion of this course. We value your feedback. Your feedback helps us to make better courses and helps us to decide what to teach next. So please don't be shy with your requests and your feedback. We do like to hear from you, and we appreciate your help in helping us to improve our broadcasts.
We certainly do.
At this time, we have no questions on the audio call.
Excellent, thank you. And I'm not showing any questions on the Hangout. So Cheryl, thank you very much for joining us. It's been a really informative 3 days, and I think there's a lot of content, but I know I feel much more comfortable having gone through these exercises and really getting into the substance of the regulation. So thanks very much. We hope everyone out there found this to be very helpful. And again, please do share with us your feedback on the course evaluation, and let us know if there's anything you'd like to see us do in the future. Until next time, I'm Patrick Shepard.